The ayes have it. Call on Government Order of the Day number 9.
Medicines Amendment Bill, second reading.
The Honourable Maurice Williamson.
Mr Speaker, I move that the Medicines Amendment Bill 2011 be now read a second time. I'm pleased that after looking at the bill, the Health Select Committee has recommended it should proceed with some amendments. The committee has worked hard, and I thank all the members for their contributions. Before outlining the provisions in the bill, I think it's helpful to review its purpose to understand what this amendment will do and what it will not do. This bill will amend some specific provisions of the Medicines Act 1981 to streamline the legislation. What this bill won't do is carry out a comprehensive overhaul of the Act. In June 2011, the Prime Ministers of New Zealand and Australia announced their intention to proceed with the establishment of an Australia-New Zealand Therapeutic Products Agency, ANSTPA, under a treaty signed in 2003. The Minister of Health intends to progress a Therapeutics Products and Medicines Bill in 2013 to provide for ANSTPA. That legislation and the Natural Health Products Bill currently before the Health Committee will comprehensively overhaul New Zealand's therapeutic products regulatory system. This Medicines Amendment Bill predates the Prime Minister's agreement to progress ANSTPA. It should be seen as an interim measure before ANSTPA is established. Mr Speaker, this Bill 1 will modernise the definitions of medicine, medical device and therapeutic purpose. 2, it will amend the medicines approval process to make the legislation less prescriptive, instead specifying the detail in regulations. And 3, it will amend the prescribing framework to name nurse practitioners and optometrists as authorised prescribers and make some minor changes to licensing requirements. The submissions on the bill were generally supportive of these proposals. The bill, as introduced, also added an enabling provision for a new category, delegated prescriber, and an enabling provision for temporary prescribing rights. There were mixed views from submitters on these provisions. A common theme was the need for further information on the process for gaining and implementing delegated and temporary prescribing rights. The bill has been amended in response to this, and I will now outline the feedback from submissions and key changes for the House. Definitions. There was general support for updating the definitions of medicine, medical device and therapeutic purpose to better align with international norms. The definitions in this bill have been developed to reflect New Zealand's current regulatory framework. These definitions will be reviewed and updated again as part of the establishment of ANSTPA. Prescribing. There are currently 2 categories of prescriber in the Medicines Act: authorised and designated. An authorised prescriber is a medical practitioner, dentist, registered midwife or designated prescriber. These prescribers must prescribe within their scope of practice for patients under their care. Designated prescriber is the term used for a restricted subgroup of authorised prescribers. Currently, optometrists and nurse practitioners with prescribing rights and some registered nurses practising in diabetes health are designated prescribers. Designated prescribers are only allowed to prescribe certain medicines listed in regulation. The bill revokes the designated prescriber regulations for nurse practitioners and optometrists and names them as authorised prescribers. This will align their prescribing rights with those of medical practitioners, dentists and midwives by enabling them to prescribe all medicines appropriate to their scope of practice, rather than limiting them to only being able to prescribe from a limited list of medicines. This move acknowledges the safe and appropriate prescribing practice of these groups over the past 7 years. There was broad support among the submissions for amending the definition of authorised prescriber to name nurse practitioners and optometrists. A small number of submissions raised concerns about extended prescribing rights in terms of patient safety, fragmentation of care and increased costs to the sector. This reflects in part a general opposition to the extension of prescribing rights to people other than doctors. The bill also creates a new category of prescriber, the delegated prescriber. Delegated prescribers will be allowed to prescribe under a delegated prescribing order issued by an authorised prescriber. The competence, training and qualifications required of delegated prescribers would be set in consultation with the responsible authority. The requirements for delegated prescribers would be set at a low level or a lower level than for designated and authorised prescribers, commensurate with the more limited level of prescribing and the oversight of the authorising prescriber. Generally, there was cautious support for the new category of delegated prescriber from medical and pharmacy organisations and opposition from nursing groups. The delegated prescriber category adds a prescribing option for professional groups beyond the existing categories. It will be for regulatory authorities to determine what form of prescribing rights, if any, they intend to seek for their profession. A common theme in submissions was the need for further information on the process of gaining and implementing delegated prescribing. The bill has been amended so that delegated prescribing rights will be made via regulation rather than by Gazette notice. Requiring a regulatory mechanism will allow greater scrutiny and reflect the significant responsibilities that accompany any form of prescribing. But it will still allow flexibility to tailor conditions and requirements to different groups of delegated prescribers. Further consultation and education on the details of the delegated prescriber provisions will need to occur during development of the regulations and prior to their implementation. The bill as introduced included a temporary prescribing provision to allow time-limited demonstration sites of new models of care that involve extending prescribing rights. Officials' previous understanding was that designated prescriber regulations could not be time-limited. I have since been advised that the existing designated prescriber regulation-making power does allow conditions to be placed that specify a time limit. This would allow all the restrictions that would be imposed via temporary prescribing provision to be imposed via designated prescribing regulations. Given this ability, the temporary prescribing provisions is redundant and has been removed from the bill. This bill also amends the licensing provisions in the Act to enable a licensing authority to take into account previous convictions when considering an applicant's fitness to hold a licence and to impose conditions either when issuing a licence or at any time while the licence is in effect. The bill removes the provisions in the Act that deal with medicines approvals and will replace these with regulatory making powers. The default commencement date is set at the 1st of July 2017. This anticipates that the medicines approval process provisions in the bill are likely to be superseded by the establishment of ANSTPAR, but provides a backstop should the implementation of ANSTPAR be delayed. Of the submissions that address the medicines approvals process, there was general support for the removal from the Act of the detail about the application and process requirements for the new and changed medicines and related products. Regardless of whether the approvals process for medicines is developed as a New Zealand-only scheme or as part of the joint ANSTPAR scheme, the regulations will be risk-based and provide different approval pathways to cater for medicines in different risk categories. Each pathway will trigger the application of a level of scrutiny that reflects the risk of the medicine, for example, in keeping with international norms, more rigorous scrutiny will be applied to higher risk prescriptions, etc., etc. Medicines with known ingredients can be purchased without a prescription would require less scrutiny. The regulations would be set out in the eligibility criteria for the different pathways and the validity requirements. They would also set out the process to be followed by the regulator and applicants to resolve or not technical queries. This bill provides an opportunity to amend some specific provisions of the Medicines Act in advance of the comprehensive overhaul of the therapeutic
Sorry to interrupt the Honourable Minister.
I commend the bill to the House.
The question is that the motion be agreed to. Ian Lees Galloway.
It's a pleasure to follow.